May it please the Court, my name is Torrey Wiegand, and I represent the appellant in this case, Dr. Santiago Paredes. As in Matsuyama, this appeal also presents the issue of whether lost chance of survival is a compensable interest under Massachusetts law. Unlike in Matsuyama, the issue here, more specifically, is whether lost chance of survival claim can be maintained under the Massachusetts survival statute, where it was claimed that the decedent suffered a 58 to 30% reduction in 10-year survival, and where the jury found no wrongful death. Similar for the reasons presented by Mr. Knight, we submit that this purported harm is not compensable, and it would require a legislative amendment of either the survival or wrongful death statutes to recognize such a claim.
So in this case, the jury found in their verdict that the doctor was not the cause of the wrongful death.
Correct. And there's no appeal from that ruling. There was no exceptions taken to below. There's no appeal from that, and there was ample evidence to support that finding. And building on Your Honor's point about Glicklich, there was no testimony, unlike in Glicklich and Kusher, that an earlier diagnosis would have prevented metastasis.
But that wasn't the only issue in Glicklich. You would agree.
Well, Glicklich wasn't a survival action.
No, I know that. But, I mean, there was the metastasis, but there was also, at least the Court discussed, the reduction in chance of cure or whatever, from 95% to...
There were statistical evidence that was discussed by the Court, but I also think that what's profound in that case was that there was a recognition of testimony, expert testimony, that the cancer would not have metastasized.
Right.
And I would say as to the statistics, it hasn't gotten the attention that it needs to, because these are how these cases are being brought, and we submit there's a bit of a misuse.
Let me ask you this. In terms of the other states, this is Justice Ireland's question to Mr. Borton, but if there are 30 other states that have recognized this cause of action, is that, or so? Is that, tell me what you think the other jurisdictions...
Okay, fair enough. I don't know. It's tough to tally where the state's position is. I do recognize there is a number of states that do recognize this concept of loss of chance.
I thought the commentators referred to it as a majority of jurisdictions. Well, they may or may not have tallied them up, but or the majority rule or the prevailing rule, or if you look at the commentators.
I think if you were to count the number of cases that talk about loss of chance in some capacity or recognize in some capacity, they might outnumber the ones that have rejected it.
And why do they accept the doctrine?
That's a good question. And if you look at those cases, they're not uniform in any respect. And as Mr. Knight points out, none of those cases really address it specifically under survival and wrongful death schemes of those states.
Well, an attorney in the last case said Missouri had a wrongful death statute similar to ours, and they adopted the doctrine.
And I believe that's correct. McCracken or the Wolin case. And in that case, it did not get into the specifics, again, in detail, why that was causing the death. In that case, it was a less than 50% proffer. But it didn't get into why that was caused the death, and that's the question here.
What does the restatement say about this? Anything? There was some allusion in the last case, Mr. Knight, that the plaintiffs were relying on the restatement incorrectly. Does the restatement talk about this at all?
It does, in some respects, and it's an interesting aspect. Section 323 of the restatement, which is the Good Samaritan rule, and it goes to some of these cases that have recognized it, which we believe is faulty. That's the Good Samaritan rule, and courts have looked to that, saying that's a recognition of a right to collect for harm that's increased risk of harm and support for loss of chance. It's not. The restatement, even the authors themselves, and we cited to the reporter's notes, have noted that while courts have looked to this provision of the restatement as support for loss of chance, it's not. And those are the authors themselves. Section 323 imposes a duty in the Good Samaritan context, and it still, by its very terms, requires there to be physical harm. So, for purposes of the restatement, those cases that cite to it, I think even by the reporter's own notes, that they don't apply.
So, Mr. Wiegand, could I just ask you a question? The judge's instructions on damages, were there objections to those instructions?
Yes.
Okay.
Obviously, there was just to work that issue through, Your Honor.
Sure.
Prior to trial, this whole issue of loss of chance was raised, and that was claimed by trial counsel that it should not be presented to the jury in any capacity. In that in that pretrial motion, it was discussed also about the fact that that if any damages were to be awarded, it would have to be under this proportionate method. This was raised again at the time of jury instructions, and submitted jury instructions for that type of method. The judge rejected that.
Okay.
And the issue on that point is there is a disagreement as to how you measure this thing called loss of chance. And if this court is going to recognize it as a compensable interest, one of the things you're going to struggle with is, what is the measure? How do we instruct juries to determine this? And there are really three methods that I'm aware of that courts have used, and they're all faulty, which I think underscores the fact that this doctrine is very difficult. And I think it does require, given our survival and wrongful death schemes, that it's got to come from the legislature, not only because of the policy interest behind the survival and wrongful death schemes, but because of the substantial social policies implicated by such a recognition of a doctrine.
It seems to me that those are two somewhat separate questions, namely whether or not the statute applies here, and then how you value, you know, the resulting damages.
They are and they aren't. And just to get back to your question, the proportionate method says, you know, we're going to have the jury determine the chances of survival at the time of diagnosis versus misdiagnosis. And then you take that and multiply it times the total death damages. The idea being, while it's a rough estimate, it at least tries to make a distinction between the harm caused by the physician and the pre-existing condition.
I mean, you heard my question before, but it seems to me that even if there's no dispute that the wrongful death statute applied, namely in a shooting or something like that, isn't that what we're asking juries to do? We don't know for how long the particular decedent would have lived, so we ask juries to take into account all kinds of things, and we instruct accordingly. We allow expert testimony and then instruct. I mean, it strikes me that that is a somewhat different question, and one that courts, you know, work through all the time.
That may be so, but going back to the Matsuyama case, the loss of the statistics were for 5-year survival. There was no testimony that he would have lived longer. It was still a 37.5% chance of living, potentially living 5 years. I don't think that's the same as, more probable than not, of cutting someone's life short, which I think a jury then could say, or could evaluate.
But following up on that, we do this all the time. I suppose it's a 65-year-old plaintiff who's killed in an auto accident due to the negligence of the defendant, so a wrongful death action is brought. The jury obviously has got to compute some damages. So they look at the man's age, you know, his health, what his medical conditions were, statistics on what the probability of somebody 65, how long they would live based on his medical conditions, and then they come up with damages. Isn't that the same thing here?
Well, I would say in this case with Renzi, it's under survival.
Well, I know that.
But
the approach is the same.
To take Justice Glaney's hypothetical, assume that the victim, the decedent, was undergoing treatment for cancer at the time. This is not unusual, right? Or was a smoker, even less unusual, unfortunately. The jury then hears testimony that if you are a 65-year-old man or woman and you smoke 20 or 40 cigarettes a day, you're going to have a shortened life expectancy, but that doesn't cut you out from having, from the jury being able to be instructed on how to calculate damages when the shortened life, because of the negligent automobile accident, caused the death.
I guess I want to make sure I understand your point. Is in a case
my point is a simple one. One is whether there's a cause of action, whether there's causation, whether the wrongful death statute does or doesn't apply, knocks this out, and so on and so forth. That's separate from saying, can we come up with reasonable ways, assuming that there is such a claim based on the negligence that caused the death, that we can value that. It seems to me that we can do that.
Well, you apparently would be leaving it to the jury to say, based on those circumstances, the value of this person's life.
I was responding to your claim that that should be set by the legislature.
But we do that all the time. On my hypothetical, the 65-year-old who's killed in negligence, I realize this is not wrongful death, but maybe this pertains to the other case, the jury's got to make an estimate based on all the variables that are pertinent to that man's age and physical condition, working, earning capacity, and all those kinds of different things, and come up with a measure of damages. Why is that any different than what they're doing here? They're
Well, again, I
dealing with
guess, and I hope I'm not trying to be responsive, is that in this case being a survival action, they are seeking, in essence, under the guise of loss of chance, to recover loss of life expectancy or shortened life. Now,
Yeah.
leaving aside whether a jury can measure that, under survival, you can't recover that because that's not a loss you experienced while you were alive. You don't suffer a shortened life expectancy until you die.
Well, would this apply to Mr. Knight's case?
No.
The 65-year-old? Why not?
Oh, Mr. Knight's case, you're hypothetical. It might, if the testimony was that, but for the negligence, he would have lived longer.
Well, that's going to be the testimony. He was, killed by negligence, and now the next question and it's the defendant is responsible for the negligence. The next question is, what are his damages?
Well, it wouldn't be his damages, it would be the survivor's damages.
Correct.
Well,
And
the states.
that's a problem with this case in Renzi, in that you can't bring a claim for loss of life expectancy for the decedent. He can't collect for it while he's alive.
Not the decedent, but I mean, just to take the two Renzi children or Mr. Renzi. I mean, if it were a wrongful death claim, they could seek what she would have contributed to the household, right?
Correct.
So why couldn't, I mean, that could be true of the 65-year-old person hit by the car or Mrs. Renzi, couldn't it? I mean, then the jury's going to have to figure out
Loss of consortium. So
how
forth.
long would she have lived, and what would that have contributed to the household, and what would the damages be?
But I don't think they can do that in a survival action. The value
Why
of the
not?
person's life.
Why not?
Because damages end don't. In this case, Renzi, the jury found that they didn't cause the death. So what's left is
that's a different question. That's why I keep trying to separate out the valuation and whether the negligence caused the death. To me, those are different.
Well, if the jury finds that the doctor didn't cause the death, then how do you figure what the doctor's damage, what the doctor ought to pay?
That's what they're saying, yeah.
Where it hasn't caused death. Something less, presumably, than if he had caused death.
right,
Something different.
right,
Right, and that's the problem. Figuring out what that is.
right. And you can say some states do in Louisiana when you're asking about methods. Some leave it to the jury. Say, look, this was the decrease in chance of survival. You put a value on it.
Right.
Would you agree with me that if a doctor negligently fails to diagnose, that they shouldn't be exonerated from some tort liability responsibility?
No, and that's a good question in the sense that I don't think we're ever saying that. In a delay of diagnosis,
why
if
not?
the doctor's negligent, you're responsible for the harms you caused. In this case, if there was increased medical expenses, this is a 7.5-month delay from the time of the alleged misread of the mammogram to the time of diagnosis. If we caused increased medical expenses, if we caused increased pain and suffering from even knowledge that there was a misdiagnosis, we would pay that. There was no evidence in this case. It's not like that they're without a remedy. But the fact is there is some uncertainty. What this whole doctrine does is lay it at the feet of the doctor.
But on your theory, if she unfortunately dies before they get to the courthouse, you get nothing, right?
She could bring a survival action through her representative for those harms she suffered during her life, lost expenses, medical
But that's
expenses.
what Mr. Knight said you couldn't do under.
In a survival action, you can bring an action for the damages that the decedent suffered during their life, but not death. You can't bring a claim for loss of enjoyment of life, or you can't bring a claim for shortened life under survival action. And that's where the survival statute and the wrongful death statute intertwine in that the survival deals with pre-death damages, wrongful death deals with post-death damages, and very specifically, the legislature says that the right to collect for the decedent's life is not with the decedent, either when he's alive or through a survival action. It resides with the statutory beneficiaries upon death. And we don't follow the English rule, which allows for recovery of lost years. And most states don't, and the English rule does it under a very complicated set of statutes. So I think this brings us all back to the fact that under survival and wrongful death, that these are statutory enactments, and that in order for loss of chance to be recognized, it would require a legislative amendment.
Does the fact that the wrongful death cause of action has a common law origin make any difference to you?
No, in the sense that the Gaudette case that I think you're referring to makes very specific that there's still a statutory aspect to it, and that is the right to recover for death resides in the statutory beneficiaries, not the decedent or the decedent's representative.
Thank you, Mr. Wiegand.
Thank you very much.
Good morning, Chief Justice Marshall.
Good morning, Ms. Gontier.
Justices. My name is Annette Gontier-Kiley, and along with Attorney Mara Sheehan, my co-counsel, we represent the estate of Mary Jane Renzi as appellees opposing the defendants' basically attempt to turn traditional tort law rich precedent as established by this court and the appellate court guiding lawyers in the bringing of delay of diagnosis of cancer cases.
Is there a case of our court or the appeals court or cases, one or two, that you specifically say will help you?
Yes,
Your
Your
Honor.
Honor.
Close to this?
Yes, Your Honor. Going back to the beginning, the plaintiff brought compatible claims of alternative claims. Loss of substantial chance of survival as clearly recognized in 1983 by Glicklick versus Spivak and its progeny, Kusher versus Turner, Gray versus Kiger or Kiger, K-I-E-G-E-R, and many other cases in the federal court referencing this court's interpretation of Massachusetts law. Glicklick, contrary to my brother's arguments earlier in the Matsuyama case, stands very strongly for the proposition that this court's focus was only one. Was the loss of the substantial chance of survival, was the diminution of the statistical chance, in this case from 58% to 30%, was that compensable? They did not focus on whether it was a greater than 50% statistical chance of survival pre-negligence, nor did they focus on whether it was a lesser than 50% chance. In fact, what they concluded is that there was independent liability, not joint and several, because there was two different time frames for the negligence, unlike in this case. The negligence that the jury found here was inseparable. December 94 and January 95, Dr. Paredes and Dr. Veach caused concurrently through their joint and several negligence the indivisible damage of causing Mrs. Renzi to lose her chance to live to her life expectancy and then to reduce it to 30%, where now she was facing the unlikelihood of living, as well as all the other damages, which are very real and which the courts, this court and the appellate court has found. And that is, they said Dr. Golub was responsible in Glicklick for a reduction from 94% to 50% chance of survival. That brought the plaintiff to below the even chance that's in Matsuyama. Then they said that Dr. Spivak, stage 2 now, the plaintiff was brought from a stage 1 to a late stage 1 or early stage 2. Dr. Spivak was found to have brought the plaintiff from a late stage 1, early stage 2 to a stage 4. 50% chance of survival till 1 or 2 years at the time of trial. And interestingly, in that case, you justices collectively have hit upon the fact that these are garden variety, my case in any event, is a garden variety medical negligence delay of diagnosis cancer case. We tried it under the precedent. All of the instructions given by the judge were absolutely under the precedent. And how did he charge the jury on the loss of substantial chance of survival? He used the model jury instruction for the Superior Court model instruction that was based on Bradford of 15 years ago, and he utilized in the jury slip that the jury should compare the value of the statistical chance of survival at the time of negligence versus, he said, at the time of the diagnosis. And with that instruction, they were able to award damages as a lump sum, as they do each and every negligent case in this Commonwealth.
With respect to those damages, I didn't read the instructions on damages, but was that meant to be let's just take the economic damages. Was that meant to be the economic damages for some life expectancy period?
The loss of chance of substantial chance of survival relates to.
I mean, what were the instructions that the judge gave that came out with $1.4 million, I think?
That's the total economic damage.
Yes, that's what I'm asking about.
The instructions that the judge gave were primarily based on if the jury found wrongful death damages. However, the expert explained that provided testimony on the elements of loss of earning capacity, to wit, loss of pension if Mrs. Renzi missed her critical milestones, which she did, and we say it was within the 10 years she would have lived, even if she died of the disease, and that because she was guaranteed the union contract to get to her maximum pension before 2005, that was a very real loss. She lost the maximum pension. And there's a footnote in the brief, and it was in the trial, that Mr. Renzi only gets as a result a percentage of the survivor benefits. Based on her stellar record and her 30-year work history, stellar commendation, she was on track under a negotiated union contract to receive maximum pension benefits.
The question is, would the damages have been the same if the doctor had been found liable for her death?
No, because if the doctor had been liable for her death, she would have been entitled for, well, as to the pension benefits, yes. As to the pension benefits, yes, because once anything causes you to breach that contract, in this case we say it was the diminution in her chance of survival which caused her to live a shorter life. It killed her sooner from the breast cancer than she would have died. She would have survived at least up to 10 years, and therefore she would have met her critical milestones under the contract.
Well, she had a 28% chance, greater chance of surviving 10 years.
She had a 58% chance of survival at the time of diagnosis, more likely than not she was going to survive. Pardon me?
So, but you're converting that to 100%, is that right?
No.
You said she lost a 28% chance of survival.
Yes.
She had a 58% chance if the evidence, as the evidence suggests, I guess, if she'd been diagnosed at the proper time, and a 30% chance when she was diagnosed. So she lost a 28% chance of survival. That's the injury.
That's correct. She went from more likely than not to live to her life expectancy to less likely than not. And the evidence supports that because she was more diseased, she went from a less than 5 centimeter, and the Dr. Glick's testimony has set forth the key testimony he gave based upon a reasonable degree of medical certainty and based upon his 30 years treating breast cancer patients and being renowned in the field, a professor of oncology and well-read and involved in guidelines and staging setting internationally. He said that more likely than not, the breast cancer tumor was less than 5 centimeters or 5 centimeters at the time of the diagnosis. It grew to 10 centimeters at the time of negligence. In August, 7.5 months later, it was 10 centimeters. He also said that there were only a few local nodes, which he explained to the jury are entirely curable in his practice and under the modalities available for treatment at that time.
Well, let's say it was 48%, and because of the delayed diagnosis, it was 20%. Is this different than from 58 to 30? In other words, if he was properly diagnosed, the chances were more likely than not that the person wouldn't have survived. Does that make a difference? You still have a 28% chance of loss.
That's an excellent question. It does. And it comes back also to the damage question. And this is why we say lump sum evaluation is the way to go here, because it allows the jury the flexibility to consider all the factors that you collectively have pointed out should come into it, and that is this. 58%, I would argue strenuously, if someone tells me I have more than an even chance that I'm more likely than not I'm going to survive my breast cancer, that's going to impact me very differently than they have to tell me, as they did Mary Jane Renzi in August of '95. Now your chance of survival, it's likely you will die of this disease. You have, instead of a 5 centimeter to a 10 centimeter, instead of a few small positive nodes, you have a massive matted node of 10 centimeter. And she's facing the same modalities. The treatment's not any better. It's the same treatment. That's a real injury. And to have lost that 58% and go below 50% to now I may not live, statistically, psychologically, emotionally, and physically, I say that's greater damage. However, the jury is free to determine whether or not it is. In some cases, the jury may think that it's greater damage if you go from 48% to 10%. And
how can it be greater economic damage?
Yeah.
Economic damage, the way we arrived at it is as follows, that by diminishing Mary Jane's life, she would have lived at least up to 10 years. Dr. Glicklick explained 10 years is the period of time by which you considered cure. If she had less of a tumor mass, if she in January of 95 had been treated with the available treatment, it is his opinion that she would not have suffered harm, that she would have maintained the 58% chance of survival, and she would have lived her life expectancy. That tumor growing to twice its size and the nodes now becoming matted and fixed such that the ability of the radiation and the chemo to reduce it is severely compromised, that caused her to
Well, what you're really saying is that your case is no different than any other negligence case, because if the correct diagnosis had been made at whatever date it was, she would have had a 58% chance of living 10 years or more. 58% is a preponderance of the evidence, no matter how you look at it.
Yes. Yes, Your Honor.
And that
also
carries the day in a civil case.
Can I just raise this question? While that is undeniably correct, I believe Mr. Borton was making a point that she would have had a 58%, but by the negligence, let's assume there was negligence, the defendants took away her 100% chance of surviving, not chance, took away her surviving 100%. In other words, you may use the 58% for purposes of calculating damages, but she could be alive today.
Well, that's true.
Even if she had a 49% probability or 22% probability. We keep mixing the two things as to how you calculate damages.
It's 100% chance of a loss of 28%.
Yeah, the 100% can't be right.
I would like to go back to more simplicity and say that in this case, we brought the wrongful death, we brought the claim for loss of substantial chance of survival under the survival statute, which we say recognizes this injury, because all of the cases have called it an injury. Loss of chance of survival is not, it's not a new cause of action. The defendants are seeking to create new law by overturning 25 years of precedent. Loss of chance of survival in the form of having your life expectancy reduced, having your life shortened, having disease-free intervals shortened. That is very relevant to the loss of earning capacity. Mrs. Renzi was reported to have gone to the school 30 years where she taught in the middle school as a public teacher in her wheelchair after she had brain metastases. There is no doubt on this record that she would have, had she lived to even under 10 years, even if she didn't survive her cancer, that she would have met her contractual obligations. She would have, the jury found that her pension would have vested, and she would have had nearly $400,000 from that. Secondly, she had loss of household services. There was very strong testimony how she was the core of the family and how she was responsible for doing everything.
You say there's, and there undoubtedly was, some basis for, you know, what her economic damages. The 100%, though, is a bit fallacious, isn't it? You can't say took away the 100% chance of her living a full life.
Not chance.
Well, 100% of anything, really, because even in the best circumstance, at stage 1, I guess it was, early stage 2, she only had a 58% chance.
Again, Your Honor, that under the traditional wrongful death rules, when you have greater than a 50% chance of survival, that you prove and that a jury believes that that was a substantial contributing factor in causing the death, you have proved the death.
And but you lost on
that.
Pardon me?
But you lost on that claim.
Well,
I'm sorry, I didn't mean to distract you.
Yeah,
here's the situation. This jury answered resoundingly, yes, Dr. Paredes was negligent. Yes, it was a substantial contributing factor in causing the loss of substantial chance of survival. And they did say no to loss of substantial chance
it didn't
of
cause
causing the death. If this court were to overrule 25 years of precedence and adopt the arguments urged upon it by my brother, then we would ask, if we are going to lose that loss of chance of survival, which is an injury that's been recognized for 25 years in precedent before this court, then we would ask that in the court's equity powers that they conform the verdict to the evidence, and that it be then that they can't have it both ways, and that as a matter of law, that finding that the causation is not responsible for that the defendant was not a substantial contributing factor in causing the death is unsupportable as a matter of law. And the defendant makes that argument in the Matsuyama case.
Yeah, but you're missing my point. The jury can't go into the jury room and say to themselves, well, it's been proven here she had a 100% chance of living, because that's not the case. He took that away. It's been proven here she had a 58% chance. We don't know if she'd be in that 58% or in that 42%. Therefore, they've got to make their calculations, assuming everything else is statistically right and proven in the evidence, based on those percentages, do they not?
I agree. And to answer Justice Botsford's related question on the economic damages, this jury did not award the Renzi family death damages, both by the number. They gave them $600,000 for loss of chance. And the death damages would have been far greater because there would have been the loss of consortium of Mr. Renzi and the children for a period of time that would have been, we would have put evidence of life expectancy. And there would have also have been additional damages with respect to the loss of household services, because they would have gone out much further. Here, the household services were limited to the less than 10-year survival period, survival period that we say she would have lived. And it comes back to the jury's province. In this Commonwealth, they decide intangible damages often incalculable at first blush, by a lump sum method in their collective experience, and this is no different. They have been doing it for 25 years. The best way to evaluate loss of chance of opportunity is the lump sum, and the fact that it is the minority position, as the defendants contend, does not negate that it is the superior position, because the justices have pointed out that there are many factors in a case that a jury, in their discretion, will utilize to award damage.
Ms. Gonthier-Kiley, thank you.
Thank you.
We can take a short break.